Hello, Andrew Bethel with the Bethel Law Corporation, and today I'll be discussing revocable transfer on death deeds. They're a relatively new thing here in California, only starting in 2016, and they were initially set to sunset at the beginning of 2021, but were extended by the legislature into 2032. So since these are documents that seem to be here to stay, at least for the immediate future, I figured we should have a little discussion as to exactly what are they and what they do, because there are a little more than just the revocable transfer on death part to worry about. So firstly, one small caveat, our office does typically recommend for parties to have a revocable living trust and to title their property into that in order to pass on to the next generation, as it does provide some greater flexibility, safeguards, and protections for one's estate. But if you do just have a house and you do just want to make sure that that gets passed on to someone else, then you can go down the revocable living trust, the revocable transfer on death deed route, and we can assist you with that. So first, let's get into what exactly is a revocable transfer on death deed. So a revocable transfer on death deed is kind of like exactly what it sounds like. It allows you to pass real property, so land, onto somebody else after you pass away. But there are some elements in there that we should go and break down and kind of discuss individually. So the first element to consider is revocable. It's right in the name. So that means that you, as the person making the election as to who your beneficiary or beneficiaries would be, means that you can revoke your decision at any point during your lifetime. And of course, during your lifetime, because after you pass away is when the transfer happens, which leads us to the next element, transfer on death. What that means is after you pass away, the beneficiary or multiple beneficiaries, they become entitled to hold title to that property. It's what's done automatically, and here in the legal world, we call that by operation of law. Now, there are couple quick steps they do need to take in order to get title in their name as individuals, which would be filing an affidavit of death with the county, and for instance a grant deed, just having the title to the property put into their name. But their right to the property is effective right at your death. And finally is deed. So as I mentioned, this is a deed, and therefore it needs to meet all the normal deed requirements for filing a deed here in California. And a deed means it gets filed with the county recorder, which does mean, unfortunately, that it is a public record. But it does ensure that your revocable transfer on death deed is within the chain of title for your property. It ensures that nothing gets missed and that transfer will happen whether it be right after you pass away or sometime down the line when the beneficiary finally takes the time to update the title on that property. However, there are some other requirements and considerations you should keep in mind. So firstly, as I mentioned, it is a deed, it is a public record, and filing that deed also means you need to pay county filing fees. Each time you make a change to your transfer on death deed, or you entirely revoke it, or even set one up in the first place, you do have to pay county recorder filing fees. And those are going to vary depending on each individual property, because the fees determined by how many pages need to get filed, which is typically determined by how long the legal description of your property is, which does have to be on the deed. Next, you do have to have a clear statement of your intent. So I intend to pass this property on to this person. So that just has to be clearly stated on the deed. And one of the other very important requirements is that you have to have the full name of the beneficiary as well as their relationship to you. So I can't say I intend to pass this property on to Jim Bob as my beneficiary. You have to say Jim Bob, my brother, or my brother Jim Bob, when making that election for them to be your beneficiary. In addition to those requirements, there are a couple other considerations you should keep in mind. So a revocable transfer on death deed, it only applies to a residential property up to 4 units. So you can have kind of a a property with a couple different residents on it, but it can be no more than 4 on one piece of land. But they all have to be single-family dwellings. Next, it can also apply to condos. And then finally, you can use a revocable transfer on death deed for some agricultural land, but it can be no more than 40 acres, and that land does need to be improved with a single-family dwelling. So the whole idea regarding a revocable transfer on death deed is really to be able to transfer or pass on a single-family dwelling to a beneficiary or multiple beneficiaries. Now, those multiple beneficiaries all receive an equal share. You can't say this person gets 10% while this one gets 90%. You just have to put those names down and they each get equal portions. So if you have 2, 50-50. If you have 3, 1/3 each, and so on and so forth. Now, what if one of those people ends up passing away before you do and you don't make a revocation or a change to your transfer on death deed? So if one of those beneficiaries passes away, it does not go down to their estate. It actually goes to the other beneficiaries on your deed. So how that plays out in reality is, let's say we have 3 people who are beneficiaries under your deed, and one of them passes away before you do, and you do not update your transfer on death deed before you pass away. That means upon your passing, that property goes to the other 2 living beneficiaries, and they each get 50%. Now your next thought might be, well, what if I want to set some contingencies, or I want to pass it on to a group of people? You cannot do that either. You have to list individual beneficiaries by their full name, and you need to identify what their relationship is to you. You cannot designate a class of people to pass property onto. An example of a class of people would be, I pass this property on to my children. I can't do that. I have to list them in their full names and identify that each one is my child. And if one of them were to pass away and they have grandchildren and I don't update my transfer on death deed, well, does not go down to those grandchildren, it just goes to the other children or other beneficiaries listed on that deed. Finally, to summarize, a revocable transfer on death deed is a relatively new document here in California, but it does seem to be something that will be with us at least for the next 10 years, and I wouldn't be surprised if it gets continued beyond that. You can go down the revocable transfer on death deed route. You just have to be very specific about your beneficiaries, and just know that you cannot set contingencies or pick classes of people as your beneficiaries. You can freely revoke it, but you do need to make a new transfer on death deed if there are changes to your beneficiary status, i.e. somebody has passed away, and you don't want the result that would automatically happen, that is, go to any other beneficiaries you might have listed. And if you're in a situation where there's no living beneficiaries left and you pass away with that deed in place, then the property at that point is going to stay in your estate. There's no beneficiaries, and at that point will likely be subject to probate here in California. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.